Hello all, welcome to today's session on Indian Patent Agent Examination Preparation video series by Pathways Consulting Solutions. Today's session will focus on interpretation of statute and the Indian Patent Act 1970 Chapter 1. Interpretation of statute. The term statute denotes an act or a law enacted by the legislative authority, the Parliament of India. Similarly, the term act or a law denotes as including any ordinance, order, bylaw, rule, regulation, notification or the like that is enacted by the Parliament of India. Interpretation of a statute. The term interpretation denotes the process by which the real meaning of the act, the intention behind which an act is being passed is ascertained. It is very essential to interpret law as the process of enacting an act and the process of enforcing the act are two different bodies, such as the process of enacting is done by the legislature and the process of enforcing it is done by the judiciary. Similarly, the term construction denotes the drawing of conclusion respecting the subjects that lie beyond the direct expression of the text of the act. Hence, the term interpretation and construction are very important when you interpret the statute. Any act, such as the Indian Patent Act 1970, is published in the Gazette of India. Most important components of what is being published is the department under which the act or the law is published, the date the act was passed in the Parliament, along with the title of the act, which is commonly referred to here as the Indian Patent Act 1970. Further, each of the act, such as the Indian Patent Act, is divided into a table of contents. The table of contents provide the summary of the provisions of act. Followed by the table of contents, the act is divided into multiple chapters. Each chapter denotes a particular segment of the act. The chapters are further divided into sections and subsections. The structure of an act. The structure of the act is generally divided into a section, a subsection, a clause and a subclause. What is a subsection? Any number that is following the section and in a bracket is a subsection and it is connected with each other subsections. A clause, a number or an alphabet that is following the subsection or a section and it is not connected with each other is known as a clause. A subclause is that any Roman numeral that is following the clause is a subclause. Indian Patent Act 1970 Chapter 1. Chapter 1 of the Indian Patent Act talks about the short title, extent and commencement. It says the Act may be called as the Patents Act 1970, extends to the whole of India and it shall come into force on such date as notified by the official gazette. Section 2 of Chapter 1 talks about the definitions and interpretations that are required in order to interpret the further subsections and sections of this Act. This section defines the following: appellate board, what an assignee is, what is a Budapest Treaty, what is capable of industrial application. A capable of industrial application is defined as in relation to an invention means that the invention is capable of being made or used in an industry. A controller is a Controller General of Patents, Design and Trademark referred to in section 73. What is a convention application, which we have already seen in previous sessions? What is a convention country? Any country which is bound by a member of group countries that are commonly referred to as a convention country. District court, exclusive license. Government undertaking means any industrial undertaking carried on by a department of the government, by corporations established by the Central Provisional or State Act, or by a government company as defined in the Companies Act, or by an institution wholly or substantially financed by the government. High Court, international applications. Invention. Invention means a new product or process involving an inventive step and capable of industrial application. What is an inventive step? Inventive step means a feature of an invention that involves a technical advance as compared to the existing knowledge or having an economic significance or both that makes the invention not obvious to a person skilled in the art. These two definitions are extremely important, the definition of an invention and a definition of an inventive step. Further, it also defines legal representative. It also defines what a new invention is. A new invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the patent application, which means the subject matter has not fallen within public domain or it does not form part of the state of the art. The other definition is the definition of an opposition board. An opposition board constituted under section 3 of this subsection 25. Chapter 1 further defines what a patent is, what a patent agent means. A patent agent means a person for the time being registered under this act as a patent agent. What patented article means, what is a PCT or a patent cooperation treaty, patentee, patent of addition, a patent office, a person also includes government. This section further defines the word prescribed in relations to the proceedings before a High Court, proceedings before the Appellate Board, or proceedings by the rules under this Act. So wherever the word prescribed is used in this whole section, it has to be taken as in proceedings before the High Court, Appellate Board, or before the rules made under this Act. Prescribed manner, priority date, register, true and first inventor. Further, the chapter also discusses in this act, unless the context otherwise requires, any reference to controller shall be construed as including a reference to any officer discharging the functions of the controller. Also, the patent office shall be construed as any place including a reference to any branch office of the patent office. A case law highlighting the importance of section 2. Patent application entitled Powdered Formulation for Valgan Cyclovir. The solid state of Valgan Cyclovir HCl exhibits acceptable physical chemical stability when stored in ambient conditions. The applicant of the present invention prepared a liquid dosage form of Valgan Cyclovir HCl for pediatric patient which was unstable for the shelf life. Application was related to a powder form that can be constituted with water to form the liquid form. As Valgan Cyclovir HCl is soluble under acidic condition, it must contain an organic acid to solubilize and stabilize in water for the proposed shelf life for the resulting liquid dosage form. For the purpose of this invention, non-hygroscopic organic acids such as fumaric acid, succinic acid and adipic acids were added. Hence, the final patented formulation was Vanciclovir HCl plus organic acid that needs to be reconstituted in water to give the final solution at pH 3.8 or below so that it is stable. The decision of the patent examiner. The patent examiner argued that stability of vanciclovir below pH 3.8 using organic acid such as citric acid is already reported in the prior art via a publication. Thus, there is no technical advancement achieved from the present invention. As the patent did not involve any inventive step, it was refused as per section 50 on the ground of section 2(1)(ja) of the Indian Patent Act 1970. With this, we come to the end of session 3, Interpretation of Statute and Indian Patent Act 1970, Chapter 1. Thank you for listening in. Please leave your comments or any questions in the comment box. Please subscribe to be a part of the video series.